Good afternoon, everyone. Thank you for coming today. This is PMC Shares Landlord-Tenant Disputes, hosted by Focus on Renewal with the cooperation of MDJ Bruce Boni. My name is Thomas Petrilla. I'm the AmeriCorps Vista and Program Coordinator for Pennsylvanians for Modern Courts. We're the only statewide nonprofit, nonpartisan, dedicated to judicial independence and also civic education around our state's court system. Pennsylvanians for Modern Courts was founded over 30 years ago to this year by Governor Robert Casey. He wanted to commission a panel of lawyers, jurists, and community organizers to assess why the judiciary was held in such low esteem by the public. So what they found was that often the use of campaign money as well as judicial conduct was, and in light of recent scandals as well, led to the low opinion by the public. So Pennsylvanians for Modern Courts is involved in two aspects: civic education and judicial reform. On the judicial reform side, we are involved in merit selection reform, which means that we are advocating for, instead of elections for appellate judges, we are advocating for a merit-based selection system. We are also advocating for bail hearing reforms. In Philadelphia, where we are headquartered, we have been on the forefront of advocating for bail elimination as well as other criminal justice reform. We are also involved in civic education, which is what you are all participating in today. We are involved with educating the lawyers through continuing legal education, as well as judges. So we're mostly focused on ethics, how to be an ethical judge, how to be an ethical lawyer, and how the law can better serve people. We're also involved in our program, The Media, the Courts, and the Council, which is a way to synthesize the knowledge of judges and lawyers with that of the media, so that they're better informed of processes with the courts, as well as the media can better inform the public of what is happening in their court system. And then we have our community outreach program, which is PMC in the Community. So PMC in the Community is my love child. It is a threefold program. PMC Watches is our court watchdog program. So we train volunteers to go into courtrooms to observe hearings. We do this with bail hearings to see if promises by elected officials are going to be followed through, which is the elimination of bail. We also have PMC Listens, which is a warm line where people can call in with their questions about the courts, and they can ask questions regarding judicial conduct reviews and what our programming is as well. And then we have our PMC Shares workshops, which are a suite of about 5 different topics, ranging from landlord-tenant disputes to court basics to family court as well. Any questions about PMC? So, to evaluate the effectiveness of our programming, we ask that all of the participants participate in a pre- and post-questionnaire. We're going to take about 10 minutes to do the pre-questionnaire, and this is just to evaluate the effectiveness of our programming today. So if you could put your name at the top and write pre for this instance, and then post for the next one. So we'll take about 7 to 10 minutes to finish this. All right, so without further ado, I'd like to introduce to you Magisterial District Judge Bruce Boni.
Thank you. Thank you, Thomas, and welcome. Thank you for coming today. I'd also, before I begin, just like to thank Pennsylvanians for Modern Courts for organizing this event and for publishing this wonderful pamphlet to educate people on landlord-tenant issues here in Pennsylvania courts. I'd also like to extend my gratitude to Focus on Renewal for hosting this event today. As Thomas said, my name is Bruce Boni. I am a Magisterial District Judge in Allegheny County. That is a mouthful, but what I do is I manage a docket in my court, which is just a block away here. Magisterial District Courts are entry-level courts, and they're located within the community. Obviously, everyone's familiar that the courts of common pleas, the trial courts are downtown in downtown Pittsburgh, and that's for the whole county. And each county has a county seat where the courts are. But the district courts are really where many disputes are settled initially. And you know, we have jurisdiction over really various kinds of legal issues. Not all, but many cases start at our court level. District courts do hear and decide landlord-tenant disputes. These are for matters that are involving properties, rental properties that are within our geographic jurisdiction. So, for instance, my court is located here and I cover McKees, Roxborough, and Stowe Township. So for rental properties that are within these geographic boundaries, those cases would start at my level. So the court, a district court for landlord-tenant issues, is designed as a safe space to resolve really even the most contentious disputes between landlords and tenants. And we do this in a calm, orderly way, applying consistent rules. Those rules are laws, essentially, and terms that are in leases. But you know, oftentimes people can't settle their disputes among themselves, and so they need to have someone else, a third party, an umpire, to make these decisions and to determine what the outcome is going to be. And that's what these courts are designed to do. Now, the judges who hear these cases and make these decisions are neutral. They don't have bias for or against any of the parties before them, you know, we just basically take the facts and apply the law and make decisions. And so that's what we are designed to do. Now, I do understand that the courts can be intimidating to many people, but one of the things we're hoping to accomplish here is to assuage people's fears and let you know that these courts are designed to serve you. To settle disputes that you can't settle otherwise. Now, of course, we all, even the courts, collectively have a hope that, that parties, landlords and tenants, can resolve their differences amicably on their own without having to resort to the court system. But that, unfortunately, doesn't always happen. And occasionally, parties will continue to disagree. They reach an impasse. And when that happens, they need, as I said before, a third party to decide the matter. And when we're talking about landlord-tenant issues, we are talking about essentially possible money judgments, rulings that one party owes the other party some amount of money. Could be rent, could be other things. And possible possession. Possession is the right to retain one's real property. So that's essentially when we're talking about evictions, where the courts can grant possession of a property that would essentially authorize the landlord to evict a tenant. So we'll get into all the details here, but I just wanted to give you sort of a background. Our purpose here today is in part to demystify the courts and the court system, the legal process that is involved in settling landlord-tenant disputes. And we're going to try to do that by preparing both landlords and tenants to navigate this system. And we're doing this to, in some way, make the whole thing less intimidating to people, And we're also doing it so that judges, like myself, can get all the information, all the facts and evidence that we need to apply the law correctly and then render fair decisions in every case. And the better prepared the litigants, the parties, plaintiff, defendant, landlord, tenant, the better prepared they are, the easier it is for a judge to sort of sort through the details and get to a fair ruling. Okay, so what we're going to do, our whole presentation here today is really going to emphasize, one, how to best prepare for court proceedings, and then what to expect when you actually have to go to court and litigate a matter. There are just a couple caveats that I want to share with everybody just so that we have this perspective going through the rest of the presentation. One, this presentation is not intended to be comprehensive. We could have a day-long seminar or multi-day seminar to deal with all the myriad issues that can arise in landlord-tenant disputes. And that's not really what we're going to try to do here. Really, what we're going to try to do is give you a basic foundation of what to expect so that you can understand sort of what is happening and hopefully why it's happening. And that will hopefully make a more positive experience for everyone, even people who are ruled against in some way. The other caveat that I just want to mention is that judges are different. Okay, so your experience in one court may be somewhat different from the same kind of a case in a different court before a different judge. And the law is the same. The landlord-tenant statute is the same throughout all of Pennsylvania. But the idea here is that there is still, within every judge, there is some amount of discretion that is going to vary. And there's also, judges will have different approaches as to how they are going to format a particular hearing. And by way of explanation, I'll just say that people are entitled, either party or both parties are entitled to bring legal representation, a lawyer, with them to any of these hearings, should they wish. They don't have to have a lawyer, but you can. But I will tell you, in my experience, at this level of court, roughly 99% of the cases are what are called pro se, meaning neither party is bringing an attorney. Sometimes, if the case goes up on appeal, people will get counsel. But at this level, it just doesn't happen that frequently. Well, that puts a little extra responsibility on the judge because the people who are in front of us are largely non-lawyers themselves. They don't have lawyers representing them. I need to basically guide them both through the process, through the hearing. And so understand that I'm going to give you the basic background, but there is some variance in different courts. The other thing is that there are rules of procedure. There are rules of evidence, and there are rules of civil procedure that apply in these cases. Obviously, when nobody has a lawyer in the room, sometimes these rules can be somewhat relaxed. Sometimes the format can be changed a little to accommodate sort of a smoother process. But look, I hopefully will give you all a basic understanding of what's supposed to happen in an overarching sense. Okay, the next thing I want to, and by the way, the idea here is that no matter what your experience before a court, if you disagree with the judge, how the judge proceeded, with what evidence the judge took into consideration, or just if you just disagree with the outcome, the big caveat here is that everybody has the right of appeal. Okay, this is not the Supreme Court, and it's the first step. And so the hope is that everybody will hear a case, or that when a case is resolved here, maybe the parties will accept that ruling and kind of sort of move on with their lives. But everybody does have the right of appeal to the Court of Common Pleas. And so if people are dissatisfied with any part of the process, they can exercise that right. Okay, so the rest of the presentation is going to be structured sort of chronologically. The first thing we're going to do is, the presumption is that a landlord owns property, rental property, has rented to a tenant, there is some kind of a lease and some dispute has arisen between them. And perhaps that dispute is not resolvable by the parties, and there's consideration of filing some kind of a legal claim. So we're going to start with issues that arise pre-filing and the filing of a landlord-tenant complaint, leading up to that, and then the filing itself. And then we're going to move on to preparing for an actual hearing. And third, we're going to talk about actually going to court. And then last, what happens post-hearing, including appeals. Okay? So I'm going to start now with pre-filing and filing. And any questions? There's going to be questions at a period for questions at the end, but at the end of each section that I'm dealing with here, if there are specific questions, you can raise your hand, and I may decide to postpone answering that until the end, but while it's fresh in your mind, that's fine. Okay, so pre-filing. Okay, we're going to start with the idea that if you have a landlord and tenant, they have a relationship, a business relationship. There are a couple things that apply. First off, landlord-tenant law is the intersection of two major areas. On the one hand, it deals with the law of contracts because leases are a type of contract. But it also deals with the law of real property, okay? Because we're dealing with real estate, and these are two large bodies of law, and so they can be quite complicated. We're also dealing with individual leases. Now, leases themselves, separate from the statutory law, can be very simple, they can be very long and complicated. And so it's not necessarily easy to deal with. The landlord-tenant statute in Pennsylvania is fairly long and involved, and it's legalistic because it's a statute. It kind of has to be. So these are often people can refer to these when they're trying to figure out how to resolve a dispute, but it's not necessarily obvious or easy to everyone, and that's why the courts can step in and play a role. Okay, so let's come back to leases. Okay, leases can be in writing, or they can even be oral. If it's less than 3 years in duration, it can be oral. I would say, I'm not going to give you a whole bunch of legal advice here, but I would say, in general, written leases I think are preferable for both parties because they can specify what are the terms that the landlord and tenant are entering this relationship on. And it's in writing, hopefully it's clear. It can also help the judge in interpreting those provisions. And so, but again, it is not legally required for a lease to be in writing in many cases. There's also no standard version of a lease. There isn't just sort of one format for Pennsylvania leases. Many times, landlords sometimes they'll write up a lease themselves. Sometimes they'll search the internet and find a lease and they think it sounds good. They might add some provisions, take away some provisions. There are myriad kinds of provisions and terms and conditions that can be added to a lease. So that can make a dispute unique for many different landlords and tenants. There is a law that requires that residential leases in Pennsylvania be in what we call plain language, essentially not complex legalese that only lawyers would understand. They're not all like that, but that is the requirement so that anybody, a reasonable person reading this document as a tenant, should be able to figure out what are the rules of the road here. What are my obligations under this lease if I sign it and move in? Okay. The goal here is most of this is going to be talking about disputes, right, where the parties just can't agree. But the idea really is that the parties are encouraged, the law encourages parties to communicate as much as possible to try to resolve matters before they have to resort to the courts. Many times people file claims, legal claims, because They wanted to resolve a matter, but they couldn't get a hold of the other party. People didn't return calls. They just wouldn't respond to letters. And this is on both sides, landlords and tenants. And so, communication can often avoid the necessity of having to go to court, but it doesn't always work out. If there is a dispute and you're a landlord or a tenant and there's a dispute about an issue, then and you can't seem to work it out, well, you should take a look at your lease. Are there any provisions in the document that would address this particular matter of contention? You might also want to look at applicable provisions of the landlord-tenant statute. I know that that's not necessarily the simplest thing to do, but it may help you understand how the law sort of sets up the structure of landlord and tenant law. You may find other kinds of information from nonprofit sites on the web that explain tenants' rights and explain landlord rights. That's a good place to start. The other thing is, either before you consider filing an action, you may, if you can't figure out what the rules are, you may want to consult an attorney. A lot of people, as I said, don't do that. Some people will consult an attorney just for a consult, whether it's a paid consult or a free consult. That's different from hiring a lawyer, retaining a lawyer to actually show up and advocate for you in court. That's going to cost more. But sometimes people will do that in advance before they decide, so they can see, well, gee, if I do have to go to court, how strong is my case? And this could be on the plaintiff's side or the defendant's side. But as I said before, largely the vast majority of the cases that I see are no one is represented in court by an attorney. That does change with appeals. The other thing I want to talk about is, if you're a landlord and you determine that you believe that your tenant has violated the terms of the lease and you really want your property back, you cannot, under the law, engage in what we call self-help. Okay? Self-help is, well, they breached the lease, so I'm going to change the locks when they're not home. Or I'm going to shut off the heat or the electricity to the building, to the unit. You can't do that. That's illegal. Okay? The legal system has set up a venue to resolve these issues in a fair way, and that is the court system. So self-help is not an option at this stage when you have a dispute with your landlord or your tenant, or in this case with your tenant, and you can't resolve it. Next, I want to talk about something that, again, this is all before a legal action is filed. You may have to take a preliminary step, and that step we call a notice to quit. That's a legal term, but it really means a written notice. If the landlord is the one who is making the claim, who is asking for possession, it's a written notice that must be supplied to the tenant, and it's basically an clear affirmative statement, written statement that the tenant has breached some condition of the lease. Could be non-payment of rent, but it could be other things too. And that as a result of that breach, the landlord wants his or her property back. So he is, if the matter is not resolved within a certain period of time, and there are different periods of time under certain situations, we'll talk about that a little more later in more specifics, but if that doesn't happen, then it is a demand that the tenant vacate the premises, leave the property. Okay, so that is a legal requirement that essentially must happen in certain situations before a person goes to court. Now, the reality is that the law allows the parties to waive the notice to quit requirements in a lease. So, if you have a written lease with a landlord and you're the tenant, it is not uncommon these days to have a paragraph that says that essentially that the notice to quit requirement is waived in this case. And that means that the landlord, if he or she determines that there's a breach, can initiate a legal action without supplying that written notice in advance. So, and I think those provisions have become more and more popular. So most, most written leases that people find on the web and say, "Gee, I'm going to use this for my rental units," it's not unlikely to have those, and so it may not apply. But if it's a verbal lease or if it's a written lease that does not have that waiver, then you have to supply this notice to quit. And I can get more into specifics about that in the question session later. But essentially, as an example, if you have a lease that's a year or less and the landlord is really just seeking unpaid rent, then they have to supply generally a 10-day notice to quit. 10 days before, they have to post this notice on the property or serve it in person to the tenant, and then allow 10 days to pass. Potentially, maybe the tenant, if there's an amount owed, pays that amount, and then there's no need to proceed. But you need to let whatever the time period pass before the landlord can actually go to court and file an action. There are other time periods. There's a 15-day notice if it's for if the breach is for something that is a breach of the lease but not rent, something else. They violated some other substantial term within the lease. So we can get more specifics about that later. The other thing that a landlord, or a tenant, should do is, in preparing before deciding to file, is if it's partly about money, then they should try to calculate what's the amount owed. Is this just for rent? Is it for rent and maybe things like late fees? Or if the lease provides that the tenant is responsible to either pay or reimburse landlord for utilities. There can be other kinds of charges, but the landlord should be clear on what kind of categories of monetary debt are we talking about here. And then you want to think about, okay, well, what is, as of the date that you file, what is already past due? What should have been paid, wasn't paid, and then the landlord wants to file a legal claim. Because the courts cannot issue what are called prospective judgments. A prospective judgment is, as a judge, I can't grant a monetary award that includes money that is not due and owing yet. It's not past due. So, for instance, I had some landlord-tenant cases this morning before I came over here. One landlord asked if they could include February's rent. Well, we're not in February yet. So even though the tenant might owe back rent for months leading up to the date of this hearing, it's not appropriate to grant an award, a civil judgment essentially, for money that is not yet owed. So the next thing that a landlord is going to want to do is, when you've got your ducks in a row and you think, okay, I need to go to court. So you contact the court, find out what's the district court that serves the community that this property is in, and contact the court about the process, how to file, and what is the filing fee, because there's going to be a filing fee for initiating an action. And in fact, I do later, if people want to take a look, I just brought some blank landlord-tenant complaint forms that are used here for initiating actions. And you can see there's check boxes, there's lines to fill in information. And again, we can talk about that more specifically a little later. But essentially, you need to, as if a landlord is initiating a landlord-tenant action, you need to fill out the form, the complaint form, with as much specificity as you can. The idea here is that in filling out the information, and there's not a whole lot, you can't write paragraphs on these forms, but the idea is to give the defendant, the person who is going to get notice of this, that they are being sued and have to go to court, to give them notice, proper notice, that of what's the nature of the claims that are being brought. Because if I've been sued and I don't really, and everything in the complaint is kind of vague, then how do I know how to prepare? How do I prepare a defense if I don't know what I'm being sued for? How much money is it? Is it rent? Is it something else? Are there other alleged breaches? And so it's really important to try to be as specific as you can at the moment when you're filling out these forms. Okay. So, and the other thing is that I have a very informed and helpful court staff. And they're the ones that really receive the complaints, they take the filing fees, and they set up all the hearings and everything. But as informative as they can be, they are not allowed to give legal advice to anybody, really. And so the idea is that you can ask lots of questions about the procedure and the forms, but you can't say, well, gee, should I do this? Should I include this kind of a claim, or should I not? Those are questions that, to be answered, would require a legal opinion. And they're not allowed to do that. If you really want a legal opinion, you have to talk to a lawyer. Okay? So that is just the reality of the situation. Okay, so say you file the claim, and what's going to happen is the court staff is going to then arrange for the defendant, whoever the defendant is, to be served with notice that they've been sued and that there is a hearing scheduled. And this is done through the mail, and it's also done by posting the notice on the subject property that we're talking about. The other thing that the staff will do is schedule a hearing. Now, in Pennsylvania, we have to do this schedule the hearing within 7 to 15 days of the filing. Because in many, maybe not all, but many situations, landlords and tenants need resolution quickly. Everybody's probably familiar that with civil cases can drag out for long periods of time, depending upon what the nature of the claims are. But with landlord tenants, the whole design is to give people some finality with the right of appeal, but nevertheless some kind of initial closure fairly quickly. So, the hearing's going to be scheduled. Now, I will tell you that if a party finds out their hearing's been scheduled and there's just an impossibility of attendance, they can request a postponement. In these cases, because there's an interest in trying to get prompt adjudication, they're disfavored. We don't like to grant too many postponements, but I would say as a rule, one per party is, if necessary, but it's in the judge's discretion. Otherwise, we really want to have this hearing and get a resolution. Okay, so that's the part that that's the sort of the end of the initial section with pre-filing and actually filing the claim with the courts. I'm going to move on now to preparing. You've got a court date, it's coming up. Hold just a second. You've got a court date, it's coming up, and how do I prepare for this? What do I need to do next so that I can best protect my own interests at the hearing? You had a question, sir.
Sign up there says the plaintiff must serve the complaint. I've never been offered that to serve the complaint myself, or defend it myself. They always tell me pay X amount in the month for the service.
Well, that's what we do here. I mean, we serve we send out the notice because what we're doing is we're giving the people notice of that they have been sued and that they must appear at a hearing. And so, as I said before, we do it by by filing the action. The plaintiff is doing their part, and then we send the notice and set up the hearings. So that's just how we do it here.
Your Honor.
Yes.
If you could, when someone asks a question, if you would
repeat the question. Yes, I can do that. Okay. I don't know if that was obvious by my answer, but the question was something regard to a writing here that says the plaintiff must serve the complaint on the defendant. And in these LT, so in these LT cases, basically, as I said, how we do it is service by mail and also by posting on the property, and that's done by a constable. Okay, so let's move on then to preparing for a court hearing in a landlord-tenant case, okay? First thing that you're going to want to do, and this holds true for both landlords and for tenants, you want to review and organize all your documents, okay? Because they may be relevant in the case. And when I say documents, I'm talking first about the lease. I will tell you that not only myself, but many of my judicial colleagues will tell stories about how many people on both sides, landlord and tenant, will show up at a court date that is specifically for the purpose of enforcing the terms of a lease, a written contract between the parties, and nobody, neither side, has brought a copy of the lease. Now, sometimes if there's not really a dispute about what the lease said, that it doesn't pose that much of a problem, but the idea is if I am called upon to interpret a provision of a written lease and nobody has that written lease, there's nothing I can do. All I can do is hear the case on the evidence that is before me, that is presented, if the lease said something different, then the party that was adversely affected is going to have to file an appeal and try to get that resolved bring a copy of the lease. But it's amazing how many times people just overlook that it's an important document that that doesn't exclusively govern it, because there are other laws that govern this transaction, but it's a major part of how this is going to be resolved and what the parties are obligated to do. Other kinds of documents that you want to prepare are, if it's appropriate, are receipts, perhaps receipts of prior rental payment that maybe wasn't properly credited by the landlord, invoices if there were repairs done or damage to physical property, perhaps letters between the parties, physical correspondence, photographs. If there's an issue about dealing with the conditions of the property, and that's going to be brought up. If we all have in our pockets nowadays a camera that's really convenient, take some photos. Either print them out or just have them accessible on your phone. There might be inspection reports. Maybe the health department did an inspection and there is a report about conditions. Well, bring it with you. In some leases, there will be a provision that says that if the landlord has to sue the tenant for and damages and gets an award, that they are entitled to some amount reimbursement for attorney's fees if they had to hire a lawyer to help them prepare, even if there's no lawyer in court. Now, those are very strictly construed. I mean, I had a case this morning where there was a request for $150 for counsel fees, and I said, well, I'd like to see that provision in the lease, and it turns out it wasn't in the lease. So I denied that part of the claim. But if you do have something like that, if you're a landlord and you have a provision that allows you attorney's fees, you can't just claim it without actually hiring a lawyer. So you can't just say, well, I'm entitled to $150 for this claim, but I want to see the invoice. What law firm did you use? Do you have a letterhead invoice that said, yes, I charged $150 for this consult? And then if it's in the lease, I can award it. So you want to have your paperwork in order. You also want to have electronic evidence in order. I mentioned that you might have photographs on your phone or on an iPad or something like that. If there are emails between the parties that are relevant to the dispute, if there are text messages, anything like that, it's okay. I'm willing to look at to evidence in almost any form. Some judges are a little, prefer looking at something physical, but you want to have all that evidence organized. Witnesses. Okay, so I would say much of the time, landlord-tenant cases, the only people in the room, even though it's a public courtroom, anybody can come in and watch, but usually the only people in the room are the judge, the plaintiff, and the defendant. But say, based on whatever dispute is in the case, there are some other witnesses that might be helpful to one side or another to corroborate some factual allegation, etc. Well, of course, you're entitled to bring witnesses. The key for witnesses is that in order for a witness to testify in a court hearing like this, they have to have what is called direct personal knowledge of the substance of what they are testifying to. okay? So you can't bring in somebody who wasn't there when something happened, but that can only say, well, yes, my friend, the landlord here, told me that this happened. That's not probative evidence. That's not useful. But if somebody has direct personal knowledge of some incident or situation that is directly relevant to the case, maybe they saw the conditions of the rental unit. Maybe it was a person who went in to do maintenance work, and the landlord wants them to testify to that. Oh, well, sure, that's fine. Make sure your witness is available to attend that hearing, and so then you can do that, but you have to be organized in advance, because what we don't do is, and this happens more frequently than you would expect, or than I would expect, is that people show up and they say, oh, I have a witness. They're not here right now, but they could come in tomorrow and tell you what they have to say. No, that's not how we do it. I'm hearing the case. I have to go on the evidence that's being presented, that's available before me at the time. So that's something you want to do. Once you have all that, you want to organize your evidence, and I suggest, this is not required, but I suggest that people, you're going to a court situation. Because it is going to be personal to you in some capacity, there may be some nerves. There's going to be some general nerves if you've never been in court before, but there may be other kinds of feelings that you have that would likely make you a little confused when you're in this room and there's a guy wearing a robe who's ordering people around. So you want to, I think it's helpful for some people to make a little outline of what you want to say to the judge, in what order, and points that you want to make. Since we're talking about it, I'll also say that I think it's a good idea for folks when they're in the hearing, even though we're not talking about that part yet, to jot down if somebody else is testifying and you come up with a question or an issue, jot it down so that you don't forget it, because it's easy to get flustered and then forget what you wanted to raise. Okay, so these are all sort of suggestions for properly preparing. The other thing you want to think about, I think this is helpful, is, gee, maybe you haven't talked to the other party in a while, and you're going to see them for the first time when you're all sitting in the waiting room together waiting for the case to be heard. You might want to think about, gee, do I want to go up to this person and propose some kind of a settlement? You could do it before that time, but sometimes people are reluctant to settle until really everything is coming down to, oh, we're really going to go to court and I could win or lose. Maybe now I want to consider some kind of a compromise. And so, but it takes two to tango. So you have to determine, and I think it's good to think about it in advance, do I want to approach the other party and suggest maybe some resolution? Now, if you do that, and before the case is called, the parties have decided, you know what, we've worked this out, then the party who filed the plaintiff can always withdraw the case. Or they can request, well, we'd like a judgment for this amount, and it's consented to by both parties, but we think we can work it out civilly and on our own. So those are things that you want to think about before you get there. The other thing that you want to do, if you are the defendant, if you're the person that's been sued, then you want to prepare any defenses. Okay, so you want to think about, well, why do I disagree with what the plaintiff has said in the complaint, or what the plaintiff's position is? And you may want to respond to the allegations that the plaintiff has made. You may want to raise other defenses. Maybe the plaintiff didn't bring these up, but you feel that there is some reason that either justifies what you did or didn't do, etc. So just like the plaintiff wants to prepare, the defendant should do the same. And I also suggest making an outline, collecting your evidence so that it's orderly so you can find it. If you're nervous, it's right there in front of you in a file. Okay. The other thing that a defendant has to think about is, do I want to file a counterclaim? Well, what's a counterclaim? Okay, so if I'm a landlord and I am suing my tenant for unpaid rent, and the tenant determines, well, gee, the landlord, it was the landlord's fault that something happened with the property and there was a leak and it ruined my furniture, and I have a loss here now, and I want the landlord to reimburse me for that. Well, if you don't do anything, if you just show up in court that day, you've been sued, but you don't do anything else, and you show up in court and try to raise that argument, there's nothing a judge can do. The reason there's nothing a judge can do is because you have not filed the proper paperwork to request that you be granted relief. Relief is some kind of damages, some kind of money or something. And you can't do that unless you file a counterclaim. Sometimes it's called a cross-claim. And so if you don't file a counterclaim or a cross-claim, you can defend the accusations that the plaintiff made against you. So maybe you won't be liable for those, but the court can't award you any money for something that the landlord or the other side may owe you unless you file a counterclaim. Okay? So that's something to think about. And you need to do that, and if you're going to do it, you need to do it at least 5 days in advance of the actual hearing. Because this is as I said, this is a kind of a fast process. And so it needs to be done fairly quickly. Otherwise, you're not going to be able to raise it in that court hearing. Doesn't mean you might not be able to file a secondary lawsuit after that. You could file a civil action against the landlord for a completely different claim. But sometimes it's nice to be able to get everything taken care of in one hearing, one court appearance. So that's just something food for thought. All right, that's the end of the preparation section of the presentation. The next thing we're going to do is we're going to talk about the day of the hearing, going to court. Any questions about the section we just covered, the preparation? No? Okay. All right, so let's move on to court. Some of these may be obvious suggestions, but I think it's really worth basically making things clear so that everybody is comfortable, at least as comfortable as they can be on the day of the hearing. If your court hearing is scheduled for 10:30, make sure you're there by 10:30. Go a little early if you can, because the idea is that if the case is scheduled for 10:30 and the judge calls the case, meaning says, I'm ready to hear this case because it's at least the time that it was scheduled for, or maybe shortly thereafter. If one of the parties is not there, then that's a problem. They're going to be disadvantaged. I'll be a little bit more specific about that shortly. But the idea is that if you can get there early, do so. You'll have some time to calm down and prepare your thoughts. The other thing that you want to do is, if you do happen to be running late, there was unexpected traffic, you had a little bit of an emergency beforehand, call the court. Let them know you're on the way. Most often, judges will, if it's not going to be an inordinate amount of time or delay, a judge will accommodate that. So do everything you can to prevent there being a judgment against you when you weren't there. Okay. Now, in my court, I give everybody, just this is a matter of custom and practice, I give everybody, both sides, about a 15-minute grace period. So if the case is at 10:30 and 10:45, one of the parties is not present, I'm going to call that case, and we're going to proceed without the other party. That's not required. I don't have to give a grace period at all. I can just call the case when I want to call the case, as long as it's no sooner than, or no earlier than the case was actually scheduled for. But every judge is different, so like I said, it protects you if you're there a little early. When you get to court, you want to go to the desk and you want to sign in. There's usually going to be a sign-up sheet, and you may even want to tell staff that you're there so that they know that one of the parties in this case is present. And then have a seat, and you're going to wait for your case to be called. And then you're going to proceed into the courtroom. Now, as I said earlier, if you want to use that time, if both parties are there and you want to have a civil conversation about the dispute, maybe you can settle it before you walk into the courtroom. That's fine. That's really up to you. Obviously, both parties have to be willing to entertain that. So say your case is called. You proceed into the courtroom. And now I'm going to talk a bit more specifically for a moment about if somebody doesn't appear. Okay, so if the landlord is the plaintiff and that person does not appear, what happens is that the case is going to be, I'm going to dismiss that case. Now, I'm going to dismiss that case without prejudice. What that means is that the landlord can't win anything today because they didn't show up for their own hearing that they filed for. They can refile that claim, they can start over again, but they're not going to get their filing fee back, and they're not going to get that initial filing fee awarded even if they file again and they have a subsequent case and they win. So that, that's on them. But in general, if the plaintiff doesn't show up, that case is going to be tossed out. Essentially, defendant wins by, just by virtue of the other party not showing. However, if a landlord is suing a tenant and the tenant doesn't show up for the hearing, and it's past a grace period if there is one, the case is called, the tenant doesn't show. We don't have in Pennsylvania something called default judgments, which is something that does happen in civil cases that are just for money, not having to do with possession of real estate. We don't have a default judgment is if the, in a civil case, is if the tenant doesn't show up, or the defendant doesn't show up, then the plaintiff can, in certain circumstances, get a default judgment in their favor. They can win what they asked for. Okay. Now the defendant can still appeal to the next court and get a do-over, but that's what a default judgment is, and we don't have that in landlord-tenant. What we do have in landlord-tenant is something called in absentia hearings. That means that we are going to proceed with a hearing. I'm still going to place the plaintiff who's there under oath and have them testify. They still have to prove their case. Okay. They have to meet their burden of proof, which is by a preponderance of the evidence. Okay. And even though there's no one representing the defendant to refute the claims of the landlord, the landlord can win what they asked for. Now, in some circumstances, when everybody shows up at court, the plaintiff, the landlord, or the tenant, can amend what they asked for if it's, like, say, an amount of money. So if here's an example. Say I'm a landlord and my tenant owes me $800 in back rent as of the date that I filed the claim. But by the date of the hearing, the tenant has paid $300 to me, and I've credited that to the account, the check cleared, everything's good. But they still owe me $500. So what I do is when I show up in court, I can orally amend the amount that is claimed from $800 down to $500. You can't collect more than what is actually owed to a party. And so that's acceptable. But it's a little different, and sometimes the amount goes up. So say, for instance, the case was filed in late January, and there was $800 back rent owed, but by the time the case is heard, it's February 7th, okay? And when the case was initially filed, there wasn't February rent due. It wasn't February yet. But by the time of the hearing, February rent has already been due and has not been paid. The landlord can then orally amend the amount claimed. Now, as long as that amendment is not so substantial that would require the judge to give the tenant some more time, then the case can proceed. If the landlord amends a new claim that wasn't on the complaint, then and it's substantive in nature, it's about a breach of the lease, and the tenant just isn't prepared for that claim because they didn't get notice of it, then the judge should grant a postponement, delay the case so that the party can get their what we call due process of law, which means notice of the claims that are going to be heard against them so they can prepare that defense. So that's important. But getting back to the idea of an in absentia hearing, if the plaintiff there proves their case, says, this is the amount that was owed under the lease, wasn't paid, et cetera, then the judge can award that amount, no more than the amount that was initially claimed, but it could be less, it could be up to that, and they can award that even though the defendant was not present. Okay? Again, everybody has the right of appeal, but that's important. So it is important, by the way, for anybody, if you are the suer or the suee, then it's important to show up for your hearing dates. Sometimes people choose not to, or they tell the other party, I'm not going to show up. That's up to them, but you just don't want to be prejudiced in an unexpected way just by not showing up. Okay. So assume that both parties are there, okay, and the judge is there. Then the first thing the judge is going to do is swear people in. Oh, this is my court. So I'm sitting up here. You can't see it on this, but this says plaintiff there, and this says defendant. And so landlords, well, whoever the plaintiff is, whether it's the plaintiff landlord or a plaintiff tenant, is going to sit there, and the other party is going to sit there. And then there are seats around the perimeter for witnesses or other people. People can bring friends and family to courts just for no other reason than moral support, right? They just want to have somebody that they know in their corner who's sitting there with them, just so that they can feel a little more confident. That's perfectly fine. Okay, so after the judge swears in the witnesses, swearing them to tell the truth, then typically, as I said, if there's no lawyer in the room, then the judge is really going to, in any case, the judge is going to lead the proceedings. The judge is going to not assume that the parties know who speaks first, what do they say, and so the judge will tell the parties who's going to speak, what they're going to do, and explain everything. The plaintiff proceeds first. Whoever the plaintiff is, whether it's a landlord or a tenant, they go first. That's how we structure it. If there are amendments, as I just covered, then that would happen initially before we move on to the substance of the claims. The parties should be, and this is for both parties, when the plaintiff presents the plaintiff's case or the defendant presents the defendant's case, the parties should be respectful. And when I say respectful, I mean respectful to each other. Sometimes there is interaction between the parties, and there's obviously interaction going on between the parties and the judge. The people should be respectful. They shouldn't be yelling. There should not be interrupting of anybody. If somebody's speaking, let them finish. There's always going to be time to respond. It's not a forum for a shouting match to resolve things. Sometimes people watch television shows that are sort of courtroom situations that, for dramatic effect, things get out of hand. That is not the job or the business of the courts of the Commonwealth of Pennsylvania. This is a way to have a civil presentation of whatever dispute there is in a calm and professional way. So that's important. I've seen people make faces. I've seen people, when I'm looking down at paperwork, I've glanced up to see people flipping each other the bird. None of that it's not the time and place. No matter how people feel, no matter how emotional the issues are, this is the time to just be calm and present your argument. I'm also going to give a little bit of just general advice for almost any court proceeding. Whatever you are presenting and that you're asking the court to do, it's a good idea to be reasonable, right? Because a judge, in hearing these cases, not only listens to all the facts and applies the law, but sometimes there is a clear difference of opinion on what happened or what was said. He said, she said situation. Well, guess what? In those situations where there isn't clear evidence of which person is telling the truth or which person has a more accurate idea of what happened, then the judge makes a determination, and what comes into play is credibility. Credibility of the person making those statements or putting forth those allegations. And so, judges are going to look to, in determining which party may be more credible, are going to look to everything else that party did in the hearing from the time that they walked in the door. Do they appear to be reasonable in most contexts, and is the other party being unreasonable? Well, if that's the only distinction between the two, guess which person the judge is most likely to think is perhaps the more credible witness. That's just reality. So think in terms of if you were listening to somebody else give your argument, how would they best present it in a reasonable way? That is, because reasonableness goes to persuasiveness. It just does. Okay. In court hearings of this nature, in adversarial proceedings, parties have certain legal rights. As I talked about before, I just briefly mentioned the idea of there are rules of evidence, there are rules of civil procedure. Lawyers know how to follow them. Lay people don't. They wouldn't. They shouldn't be expected to. But they do apply. And so one of the rights that a party has is called cross-examination. Everybody knows what that is. That's after a witness has testified, the opposing party, usually through their lawyer, but not always, has the right to ask the witness questions to clarify and maybe rebut the testimony. Now, people who are not lawyers are not, by and large, not really good at cross-examination. That should be obvious. It is hard because there are certain questions that can be asked and there are certain questions that are not proper. I will alert people to their right to cross-examine witnesses, but I also explain to them that if you're not comfortable doing that, you don't have to cross-examine a witness. You can just wait until the plaintiff or the other side is done with their case and then just present your case. I may ask some questions of each side, but that's the prerogative of the party. I'm not making that decision. It's the party that gets to decide if they want to ask questions. In reality, when people say, well, yeah, I'd like to try to cross-examine the witness, sometimes what they'll do is they'll just start stating their case. Well, I didn't do this and I didn't, and it's not for stating your case. There'll be time for that. It's specifically for asking questions that relate to the scope of the testimony that was just testified to. And so, it is a right, but without being a lawyer, it's often, when it's exercised, not fruitful for that party. But, I don't want to necessarily dissuade people. It's their right. Next thing I want to talk about is, so the plaintiff has done everything that the plaintiff wants to do. Has testified, explained their position, presented documentary evidence, any other kind of evidence that they wish to, has stated their case. Then the defendant gets to go if there's no cross-examination. They're going to present both their defense to the allegations that were made. This could be, if it's a rent situation, maybe they say, well, gee, the landlord is suing me for January and February's rent. Well, I paid January's rent, and I have a receipt for it right here. Okay, that's great evidence, a receipt. But a lot of times people don't bring that stuff. They just say, I paid it, or I think I paid it, I'm pretty sure I paid it, I paid some of it, but without having any evidence to support that, it's really a difficult position to sustain. There are other kinds of defenses that in landlord-tenant cases that particularly a tenant can raise that aren't necessarily directly related to the allegations that the plaintiff made. An example of this would be, in addition to a lease, and I'm not going to get too far in the weeds in this now, we can talk about it later in questions if you want, but as I said before, a written lease can have all kinds of provisions in it, okay? But there are some protections that tenants have that it doesn't matter if they're not in the lease or not, a tenant still has those provisions. Those are implied by law. One of them is called the implied warranty of habitability, okay? That means that if I'm a landlord and I'm renting you a unit that is for residential use, you're going to live there, then the condition of the unit has to be such that people could live there, okay? If the landlord doesn't provide a livable space at any point throughout the lease term, then the tenant has legal recourse. Now, the biggest example, the most common example of this is, if I rent a unit in Pittsburgh and it's January and there's no working heat, the furnace does not work in this unit, okay? That is not livable because we're in Pittsburgh. Maybe if we were in Southern California or South Florida, it wouldn't be that big a deal. But here it is. And that needs to be repaired very quickly because nobody can live there while it's not. And you also can't, a landlord can't be expected to demand rent for a period where the unit itself, the thing that you're paying rent for, is not livable. Okay? there's a lot to the implied warranty of habitability, and there are other implied warranties that I'm not going to go into right now. We can always come back to that later. But the idea is that would be the time and place for raising those kinds of issues would be in the defendant's case when they have the opportunity to present their defense. Okay, after the defendant goes, the judge may allow the plaintiff to have somewhat of a rebuttal to some things that the defendant said. The judge may also ask questions. The judge can act as sort of sort of the lawyer in the room and say, well, you said this before, I'd like to clarify. What did you mean by that? Or can you repeat what you said earlier? And you can go back and forth. And the reason that sometimes will happen is because the judge has one goal. The judge's goal is to conduct a hearing to acquire all the material evidence, the important evidence that would be necessary to resolve the claim. So I have to get certain facts, and I know which ones are important for the particular claim, and then I apply the proper law, and it gets me to a fair decision, right? If I don't know, if nobody's testified to a really important fact that would be necessary for me to decide a case, I don't just throw up my hands and say, well, I don't know. I ask the parties. And so that can happen often, especially when there's no lawyers present. Okay, so say I get everything I need to know, and I'm ready to make my decision. Most of the time, I'm going to make that decision by announcement in open court before the parties. Before they walk out the door, they know what I've done and what I've said. So the idea here is that everybody's clear on what the outcome of this particular case is. Now, there is a possibility in complex cases where the court is going to need extra time to maybe research law, or maybe just think about things, or review invoices or documents that have been submitted. A judge can take up to 3 days to issue a ruling. That's my right to do that. Typically, I try to give people closure before they walk out the door, but sometimes that's what happens. The other thing that I will do is, so I'm announcing if there's money damages to any party, I will announce how much that is, and if there's possession involved in real estate, I'll announce what that is, whether or not possession has been granted in some form. Again, just to reiterate, everybody has the right of appeal. Everybody, either party who is dissatisfied with any part of the outcome can file an appeal. That appeal is called de novo. What de novo means is it's a complete do-over. If you file an appeal to the Court of Common Pleas, you start fresh. What I did, or what any judge like me did, doesn't matter. It's a do-over. Okay? But for purposes of moving on with their lives, a lot of people choose not to do that. Even if they're a little bit dissatisfied with the outcome, a lot of times what they'll do is just say, okay, I accept this, I'm going to just move on and not appeal. There are a couple kinds of, when we're dealing with possession, and I'm going to try to go a little faster here because I know we're timing-wise, I don't want to go too far over, and I do want to allow time for questions, but there are, when we're talking about the award of possession, meaning that a landlord has been awarded possession by the judge. There's a couple ways that can happen. We informally refer to them as pay and stay or pay and go. Okay? The big difference here is that if I award possession and it's pay and stay, if the tenant owes an amount of money to the landlord, and I've ruled on it, this is the amount that the tenant owes. If the tenant makes good on that, pays all the amount that's owed, plus reimbursement to the plaintiff for filing fees, by a certain time frame, and I'll get to that shortly, then the tenant has the legal right to remain in the premises to continue under whatever existing lease terms they had. Now, obviously, as new months occur, the tenant is responsible for new rents, right? But essentially, the tenant can defeat the eviction order by paying the amount that the judge has decreed is the amount that's owed, plus the filing costs. Now, pay and go is, if the judge orders that, then that's essentially an outright grant of possession. What that means is that even if the tenant owes the plaintiff an amount of money as part of rent or some other charge under the lease, even if the tenant pays that amount, to the landlord in a specified period of time, the tenant, it has to go, because the landlord has proven certain conditions that entitle the landlord to get their money or their property back. And essentially those are what we call material breaches of the lease. So if you have, maybe you owe the landlord some money, but you also, the lease says you can only have, under this lease, you can only have this list of people living in the premises. And guess what? There was evidence that the tenants brought in extra people who were living under the roof, not just guests, not just short-term guests, but other people living there in direct violation of the lease. Then the landlord can say, hey, look, I don't care whether the person pays me the money they owe me or not, I want my property back. This is a material breach of the conditions that we both signed to and agreed to. Okay? If that were proved, then the person would have to leave regardless of whether or not they pay an amount of money. All right, I'm going to move to post-hearing now. Okay? So you've had your hearing, the judge has probably decided and told you what the outcome is. Now what happens? Okay, I always encourage, regardless of what the outcome is, I encourage the parties to continue to communicate openly so that each party knows what the other party intends to do as a result of the decision. Okay? The reason is that, that sometimes, even though there was a court decision, things can be settled amicably, meaning that if there was an award that's a monetary award, fine, the other person pays the award and then the parties continue on. And the judgment is satisfied. If cooperation can often resolve these things post-judgment too, it's always a good idea. Now, if there is, after the hearing, if there's an amount of money awarded, even if it's pay and stay, if 10 days pass, that's the appeal period. Either party can file an appeal, but they have to do it if there's possession involved within 10 days. That's a really short appeal period. Most appeal periods for civil cases, in a case where it's a landlord-tenant but there's only money awarded, there's no possession, there's no grant of possession at all, then it's a 30-day appeal period. But if the appeal is not filed, what happens is my order then becomes a final order. It becomes fully legally enforceable. Okay? Now, if after that 10-day period nobody's filed an appeal, then what happens is, hopefully the parties have communicated, the parties have worked out, if not coming current on any amount that may be owed, at least worked out a timetable that both parties can agree to. And if they do that, and everybody's on the same page, then nothing else needs to happen. But if the 10 days pass, and on the 11th day, usually after the date of the hearing, if say the landlord got a judgment for unpaid rent, and they haven't heard hide nor hair of the tenant since then, and they've tried to contact the tenant and the tenant doesn't respond, the landlord can come back to my court and request and pay for what's called an order of possession. An order of possession is just a piece of paper, but it gets served to the defendant or posted on the property, and essentially, even though it's a legal document, it's saying to the tenant, hey, if you want to stay in this property, you best talk to the landlord. It's really important that you talk to the landlord, try to work something out, because a second 10-day period starts at the service of the order of possession. If at the end of that second 10-day period nothing has changed, guess what? The landlord can evict the tenant. They don't do it. They request a constable, and one of my constables would perform an ejectment and lock out the tenant. That can be avoided if the parties work together and agree to some timetable. Now, these judgments are good for 120 days. So a landlord doesn't have to immediately, the first day that they're able to, go and get an order of possession or execute on it. It can be done within 120 days. If you don't do it within 120 days, then the landlord would have to start over again. But these can last a long period of time, and so sometimes the parties will agree to an extended repayment plan. Like maybe the tenant's going to pay their regular rent and then an extra $100 a month until the old balance, the judgment, is paid off. And if the landlord agrees, great. If the landlord doesn't agree, then the landlord can proceed with the process of eviction.
I think now we should move to some questions.
Okay.
So people have,
That's fine. Yeah. Any questions about anything that I've said or didn't say? Go ahead. So security deposits. When you move into a property, sometimes landlords don't ask for a security deposit. But if they do, the first year of a lease, it can be up to 2 months' rent, essentially. If rent is monthly, and say it's $600, you can say, well, before you move in, I need $1,200 in security deposit. Okay. Now, technically, after the first year, so say a tenant is in a unit and they've served a full lease year, and then they renew, and we're in the second year. Technically, landlords are supposed to return, if they've got the full double, they've got to return the half of it so that the landlord is now holding no more than 1 year's rent. Okay, 1 month. Now, does that happen in reality? I don't see it. I don't know that landlords really understand that. I don't know that they know it. But that's the law. That's what's supposed to be. There's lots of things about security deposits. They're supposed to be in interest-bearing accounts. They're supposed to be segregated. A lot of things are not quite technically according to the law, but the key for security deposits is after the tenant is moving out, will the security deposit be returned? And it must be unless there are damages to the property that are beyond normal wear and tear. And there's a whole time frame for that, but that's the key. And that's when when the landlords don't follow that, and they were obligated to, that's when tenants can bring an action, bring a civil action in my court for return of the security deposit. And under certain conditions, they can ask for double damages. They can get double if the landlord really failed to strictly adhere to the rules. Okay, any other questions? Go ahead.
If the tenant doesn't speak English, what's the process like for getting an interpreter?
Sure, call the court. Call the court in advance. Hopefully, if we have notice in enough time, we won't have to reschedule the hearing. But if we don't for some reason, we can I can reschedule the hearing so that an interpreter can be present, and either party can do that. And it doesn't have to be. I mean, it can be just someone with limited English proficiency. Maybe they speak some English, but there are legal words that are thrown about. It's maybe words that they're not familiar with. So an interpreter can be requested, and the county will organize it.
How much time should be given?
As much as possible. I mean, ideally more than a week at least. But I'm looking at my office manager there to see if she's nodding. So I would say at least that. But as soon as you realize that it's maybe an issue.
And are any of the documents that you talked about, are they required to be translated?
I know that some of, let's see, I'm not really sure about the answer to that. I don't really know. I mean, I think if you have an interpreter, the interpreter can obviously interpret for you the words, but
like serving someone, does that document?
I'm not sure. Stacy, do you have any idea?
I mean, I would just think the courts get involved once there's an actual hearing. Anything prior to the hearing would be up to the landlord to serve.
So,
Find out if the tenant understands.
yeah, I mean, what I would suggest is if a party receives a legal document from a court, say my court, and the party can't understand that language-wise, has issues, well, if they can at least figure out where it came from, the court, come to the court or call and ask, and we'll make it happen. The idea of due process is that parties have adequate notice, and if you don't understand something, then the question of whether or not that notice is adequate is a big issue. So certainly, I would make every effort to see that they got it in whatever language they needed to get it in. Any other questions? Yes.
A little bit more between the difference between a 10-day notice to quit and a 30-day.
Sure.
If I go in as a landlord to file for an eviction, they're going to ask me if I've given them a 30-day.
Yes. So again, let's talk about the premise here is that if you have to serve a notice to quit before filing, that means that your lease didn't have a waiver of that notice to quit in it. Because if it did, then you don't have to do anything. But if you have a verbal lease, or if you have a lease that doesn't that doesn't waive that right, then there are a couple different dates. If you're just going after rent, and that's it, then, and the lease is a year or less, then, first year of the lease, then it's 10 days. If you are trying to evict the tenant because of illegal drug use, there's special statutes on that. That's 10 days, okay? If you are claiming not rent, but some non-rent breach, like I said before, too many people in the unit that aren't on the lease, there's a no pet clause and you have 3 dogs, anything that's not rent, then it's 15 days if it's a year lease. Okay. The other thing is holdover leases. Holdover is if you have a year lease, and guess what? The lease ends. The landlord really wants you to go because he wants a different tenant, but you don't go at the end of that year or at the end of that lease. Then you are considered a holdover tenant. And they can ask you to leave, that's 15 days. If you are a landlord that is accepting Section 8 housing supplements, then it's 30 days, okay? Doesn't matter what you say in your lease, it's 30 days. Okay, is that good for now? Anything else? When it's 30 days, it's 30 days from the date that you post to the last date, okay, to the 30th day. So it's however many actual days, and then you can't file if the 30th day happens to be on a weekend. Then obviously you can't file until the next business day because the courts aren't open.
Right, but those 10 days, 15 days that you were giving, are they business days or are they?
Oh no, they're calendar days. I'm sorry, they are calendar days. Okay, anything else? We good? There's a lot of information. That's a lot to absorb, but I threw in as much as I could in the time we had. Thank you very much, everybody. Good luck.